All right, this is Hudson and Foster versus Kusendorf and Benson. It's my understanding at this time that the plaintiffs are representing themselves. Is that correct?
That's correct, Your Honor.
All right, thank you. And Mr. Cunningham is here for defendants Kusendorf and Benson, correct?
That's correct, Your Honor.
Thank you. And this is an appeal from Judge Cronin's decision to deny plaintiff's motion to recuse himself regarding file 13-52422NZ. So I believe that is his plaintiff's motion. So you may go ahead. Thank you.
Plaintiffs have moved to have the court recuse itself under Michigan Court Rule 2.003CB. The standard of review under that was created under Capperton versus A.T. Massey Coal Company. And that standard is when extreme facts create a probability of bias, the court should recuse itself. The extreme facts in this case is the court's continued refusal to comply with the Land Division Act of 1967 and instead using his judicial discretion to avoid complying with that very act. The probability of bias is according to Gillick versus Stockson, 297 Nish App 663 825 Northwest 2nd 358 in 2015 states an abuse of discretion occurs when the decision results in an outcome falling outside the range of principled outcomes. In this case, we will show that the court's actions were to aid and abet felons in the accomplishment of their crime. We believe that falls outside the range of principled outcomes. We are here today to ask the court to require the presiding judge to enforce the Land Division Act as it exists. On April 7, 2014, plaintiffs had a hearing on their motion for a change of venue. The court denied that, but wanted to give the plaintiffs an option to file a motion for disqualification at the pretrial hearing scheduled for May 15th. On May 15th, the court also put this option into its denial of our motion for a change of venue. It stated, if plaintiffs desire to file a motion to disqualify. Now, Mr. Finchman, who was representing us, thought that possibly this could be true, and said this might be so the court gave him the option to file it or not file it. And when that hearing on April 7th was over, I informed Mr. Finchman at that time that, I didn't believe we had grounds sufficient to have the court recuse itself. So on May 15th, at that hearing, Mr. Cudney stated that he understood that we were not going to ask for that motion and that he was going to waive his rights to that point. And that's the issue we brought up, that to that point, because what we're bringing before the court now was not in existence at that point in time, Your Honor. It happened subsequent to that time. It happened through discovery and investigation. And on the defendant's site, Unif versus McKesson Court, stating that the appellate court would not consider an issue of recusal because plaintiff did not seek recusal in court. Well, at that point in time, we did not seek a recusal because we did not object to going on without filing that motion. We didn't need to file it because we didn't have grounds at the time. plaintiff's position is that to seek recusal, we must make a connection between the court and the case before it. That we did not have. What we showed in our motion for a change of venue was the fact that I was an auditor of elections here in Allegheny County, and that there was a recount between Judge Belarjan and Judge Cronin for the circuit court seat. And I made no allegations in that that I found at a later time. This whole issue was brought to the forefront. I did 2 interlocutory appeals, and one was on a motion to compel defendants to tell us who's paying their the defendant's attorneys, who is paying the defendant's legal bills. And in that, defendant's attorney, Zach, who was working for Mr. Cudney, stated that we didn't, that I was just blowing hot air when it came to talking about this election. So in order to bring that out to the appellate court, I had to go back and review all the facts I had regarding that recount. I was there from the very beginning, and I photographed seals that were on ballot containers. And on those seals, I show 2 seals to the court. One shows a seal loosely placed on the ballot container in Fillmore Township so that it could be clipped here and someone could go into the container and change the ballots. The second one was Wayland Township, which obviously had been clipped, and someone had gone into that container. Now, Wayland Township, up until this point, I had always thought that it said Wayland on there, and I thought they meant the city of Wayland. But it wasn't the city of Wayland. And I proved that because I had gone to I had photographed the poll books and the summary sheets for the city of Wayland because it was part of my audit. And the names on these seals that are signed here were matched none of the names, and the seal number did not match the seal number in there. So this was not the city of Wayland. It was Wayland Township, and Wayland Township was accepted. So the question now comes before the court: why would someone accept a seal that had obviously been tampered with when, on the bottom of my sheet, I took notes. At the end of the day, they said they disqualified 25 of these jurisdictions. Out of 49 that was being requested to be counted, Your Honor, they disqualified 25. And out of that 25 that were disqualified, 71% would have heavily gone for Judge Belarjan, not Judge Cronin. And I make a link between Cindy Yonkers, who's in this case, and who is also part of this chain of corruption. I call it a chain of corruption because we have people that are accepting things that are obviously should have been thrown out. And that wasn't done. And Miss Yonkers, so it's not really the people who have been not counted, but the people who have been counted that are part of this chain of corruption. And Ganges Township has been recounted, has been counted and accepted in here. And one other backup was on the day of this recount, we had gone to the court and asked the court we had gone to the Ms. McKesson, who was running this. And we asked Ms. McKesson to be able to observe what was happening in an area where we could observe it. And we cited MCL 168.8743. She refused, Your Honor. And now, Ms. Yonkers also on the canvas for this 2008 general election was there. She was on the ballot and she was in the back room. And I was asked by election challengers to go in and request from the election supervisor to, under MCL 168.7331G, examine without handling each ballot as it is being counted. And we requested that as they put these into the machine, that someone can stand there and take notes and observe and take notes, which is the second part of this act, Your Honor. And Ms. Yonkers came running out of the back room saying, no, we can't do that. And we're not going to allow you to do that. And so there was the same situation between Ms. McKesson, who was not allowing people to see these ballots, and Ms. Yonkers. That's where I tied her into this chain of corruption. And now we come down to the case before the court, Your Honor. This plat was filed in 1966. I have lots within this plat. I live within this plat. When this plat was filed, Your Honor, Mallard Street was only a 30-foot wide roadway. And you can see
I do not say well aware of where you live and see a photograph of that area.
Okay. And Blue Goose Avenue is a 6-foot wide roadway.
You can't leave something on the microphone.
Oh, I'm sorry. Okay, you're right. I apologize. Blue Goose Avenue was a 66-foot wide roadway because it had residential units on both sides. And what was on the other side was unplatted farmland. And what happened, Your Honor, is this is a tax map showing the same area. It shows two developments. And it shows our development also. And it shows that Mallard Street here has residential units on both sides, yet it's still only 30 feet. Now, Michigan law would not allow that. Michigan law, it was obvious to me looking at this for a very long time that Michigan law wouldn't allow it. But I didn't know quite how it happened until just before the hearing on Judge Cronin's recusal. And I was going over the deposition of Ms. Yonkers. And in that deposition, she stated that she had no control over this land division application that had been filed. And I show a land division application in my packet here. It was in there, but it states in this land division application that the developers are not going to use Mallard Street. They're going to build their own roadway. They're going to build their own roadway. And yet, on the second page of this, it was never approved or denied. That means that the township assessor never received a copy of it, because in my packet I show where the township assessor approved another one that was over on Blue Goose with the same requirements. They're not going to build here, and to this date no one has built over there. But what happened was the bait and switch was they baited this and they said, we're not going to build on Mallard. This application never got to the forefront. And when Ms. Yonkers said that she didn't see this application until until there was going to be a hearing on it. She made the assumption that this Mr. Coates, the township assessor, would have gotten it directly. Well, if he had gotten it directly, he would have approved it, Your Honor. He approved another one just like it. And but when they issued this building permit to build on Mallard Street, Mr. Coates would have put up an objection and said, no, this application says they're going to build their own road. They're going to create their own access. That was the bait and switch. That's in direct violation of MCL 750-157A. It's a conspiracy to do a legal act in an illegal manner, and that's subject to 5 years in prison and a $100,000 fine, Your Honor. And we're looking at a substantial amount of damages that was caused by this. How do I know Ms. Yonkers and the developers conspired to do this? Well, I needed to find something that said that was contrary to what Ms. Yonkers had testified under oath at her deposition. And I went through my old files, and I came up with the Ganges Township Ordinance that regulates this application, Your Honor. And it says in several places that the township, the clerk, the municipal clerk, gets these applications and then passes them on to the township assessor. So she lied. She lied on that deposition. And so we're now stuck with this issue that this Miss Yonkers, who possibly was part of this chain of corruption on Judge Cronin's recount, which got him elected, is now going to be a party to this lawsuit, because we now have to enjoin Ms. Yonkers, the developers, and Ganges Township, because they're the ones who have damaged us. And Judge Cronin's acts from the very beginning have been to turn his back on everything we came up with to try to settle this under the Land Division Act.
I'm an objector. That's simply flat out not true.
Well, it is true, Your Honor.
Well, just keep going with your argument.
Okay. Mr. Cutney filed a motion for a partial summary disposition. We were requesting that the defendants did not have an easement to use these private roads, and that so we're asking for an injunction against their further use of these roads, because they did not have a prescriptive easement. Under the rules for prescriptive easement, Your Honor, you have to be there 15 years. They weren't there 15 years. And the court was listening to this, and in our arguments we were saying, Your Honor, this is our only bargaining chip with these fellows to try to get them to comply with this Land Division Act. And the court just turned a deaf ear and a blind eye toward all the evidence that we were presenting to them, and gave them an easement to use Mallard and Blue Goose. And he not only did that, Your Honor, but the court had also given an easement to the other parcel owners up here. All of these people, they were not parties to. They were not even parties to this case, Your Honor. And under common law, Your Honor, a judge in equity cannot give an interest in real estate to a party who's not a party to the case. And only a jury can do that, Your Honor. Only a jury. Yet, Judge Cronin gave them this easement. So we're not complying with the requirements of the Act. The requirements of the Act, which are part of this, is that the County Road Commission, the County Drain Commission, the Department of Health, the Department of Environmental Quality, all come down and check this area out to determine how it's going to be used. The court completely turned its back on any of this. In effect, the court has been, and Your Honor, I hate to use the word aiding and abetting, and when I first found this, I called my attorney, Don Finchman, and I said, Don, there was a crime that was committed here. And the best word I have is the court has been aiding and abetting these felons, possible felons, in the accomplishment of their crime. And Mr. Finchman was quiet on the other end, and I thought, I'm not going to get caught with contempt of court again, Your Honor. I'm well aware of that. And I said, that's a little too heavy, isn't it, Don? And he thought for a second, and he said, no, Pat, actually it's not. He said, that exactly defines what's been happening in this case. That's exactly what the court has been doing. It has not been complying with the Land Division Act at all. We've requested several times that we be able to make agreements with the defendants. And Ms. Hudson said she would be willing to give the 36 feet up on her property, and that they could give it up. They could take this fence out of the road. They could stop this drain from being plugged. And the defendants refused to do that. And the only bargaining chip we had was this. Now, of course, when I go back into, there's a motion for summary disposition on it, I had supplemented our original pleadings to put in that we need to file a complaint to quiet title, because, Your Honor, when these developers developed this property, they had placed this road out, and it was partially on these parcels. And when they filed this application, Your Honor, they had to file this survey. And on the survey, it shows where their parcels had encroached on this physical roadway, where the defendants now have a fence sitting out there. And so part of this conspiracy now is to quiet title and say, okay, you're going to have to take back what there's been a drainage ditch and a road there for 40 years. Now you're going to have to agree that it's been there 40 years, because this was in 1999, and the developers filed this, and they knew it from the survey. And so our position is that the appearance of a discretion, the appearance of a conflict of interest that Judge Cronin now has is the fact that someone who may have helped him get elected to his position on the court is now involved in a crime in which he is trying to help pass. Now, he may be doing that knowingly or unknowingly. I don't know. But and I'm not making any statements there. But all of his actions so far to date have been to do that. And so because we're showing some problems with the election, from that 2008 general election, and I'm an auditor, we'll be doing one other major fact. I'm scheduled to talk on several radio shows because of this. but we're going to do a petition to the Attorney General requesting that he file a complaint for a writ of quo warranto from the Michigan Supreme Court, taking elections away from the governmental bodies here in Allegan County and putting them into the hands of the people. Now that's a revolutionary change. No one has ever done this, but government, it has a major conflict of interest in running elections. It's the same as a cashier in a restaurant being able to check out what she took in throughout the day against the cash register, zero it out, and come and say, well, this is how much I have. The accountants have known for years that this is a conflict, and that if this conflict exists, you end up with an immense amount of corruption. Even honest people, it will corrupt honest people. Normally, honest people will be corrupted by that. So we're asking basically that government recognize a major conflict of interest within their own democracy, and we believe that that's going to get a lot of press.